So something that we do hear fairly often is question as to how should somebody take ownership to property. And there's three main ways that it can be done. So tenants in common is, kind of the old-fashioned way to do it, where the individuals have a 50% interest in the property, such that if anything happened to either person, the property would divide, essentially. So at the time of somebody's death, the ownership interest of the person who's deceased passes through the laws of intestacy. So primarily down to their blood relatives, or if they had a will, to whomever is in their will. Then you have joint tenancy, which offers an indivisible interest transfer so that the two owners own the property together, such that if anything happened to either one, there's an automatic survivorship provision so that then the ownership would just pass to whoever else is owning. Makes it a lot easier, minimizes any kinds of probate costs, and that's most often used for individuals who are making a joint purchase together, whereas tenants in common is done more in an investment perspective. And a lot of times what ends up happening is we do create the joint tenancy provision, but we'll be asked to draft additional documents, essentially an agreement that recites what the expectations are between the parties.
Okay.
And to that end, it helps to decide with the families what should have happened. And conversely, we do it with tenants in common so that there is no survivorship, but then we put a will in place. So if we do tenants in common, there's no survivorship, I would recommend to that couple, we absolutely need to make certain that there's a will so that if something happens to that person, their ownership interest will pass on directly to their beloved if it's not someone that they're actually married to. So that would be the recommendation. And there's a lot of different ways to facilitate that, like I said, based on the different factors. There is one more tenancy.
Yeah, please.
So the last one is tenants by the entirety, and that's reserved for legally married couples. So that's basically joint tenants with some added protection. So what that does is the joint tenancy survivorship is still available under the tenants by the entirety, but under Rhode Island state law, a husband and wife is treated as a legal fiction as if they're one person.
Okay.
So if you and Jacqueline are married and one of you is sued, they're technically not supposed to or allowed to attach to the real estate interest that you own as tenants by the entirety as a function of your marital status and your tenants by the entirety status. That's why a lot of times once couples get married, they will actually change the deed, change the tenancy to reflect tenants by the entirety. And, it happens often with women if they're changing their names or whatever, then they want to add their legal name and the new tenancy of tenants by the entirety. And it's really important that you're talking to an attorney, especially if you're not going to be in a traditional setting of we're legally married, we know how we want to take ownership as tenants by the entirety, to discuss with us what those options would be and how to go about achieving your goals.